The International Covenant on Economic, Social, and Cultural Rights, Article 11. The state parties to the present covenant recognize the freedom of everyone to an adequate standard of living for himself and his family. Well, it's not what it says, right? It says it recognizes the right of everyone to an adequate standard of living for himself and his family, including adequate food, clothing, and housing, and to the continuous improvement of living conditions. The state parties will take appropriate steps to ensure the realization of this right. All right, before I go any further, if you have no idea what this is, if you have no idea where this comes from and what this is representing, then this video is going to be a bit hard for you to understand. And you may want to go back and look at some of my older videos in order to get a better foundation for your understanding. So here the covenant says that it recognizes the right of everyone. Again, it's a right, not a freedom. And this right has not been created by them, right? It's not what the law says. It didn't say the state parties to the present covenant created the right for everyone. It says it recognizes the right for everyone. So it wasn't created by the state parties. And it wasn't created by the international community. This right that is enumerated and listed in Article 11 was not created by them, but it's recognized by them. And not only is it recognized by them, there's an obligation upon them to ensure the realization of this right. So they recognize the right, and they have the legal obligation to ensure the right. When they use a statutory instrument, like a court judgment, to try and take your home or your property from you, this action is contrary to their obligations. They are creating conditions through statutory law that degrade your living conditions. Their obligation is to ensure the realization of the right. And what's the right? Well, to the improvement of your living conditions, to make sure you have adequate housing. And when they create statutory instruments, like the court judgment, that says, get out of your house, give me your property, well, that's contrary to their obligations. And they're failing to ensure the right. When the legislators created enactments, they should have never, ever created operations of law that allow the state party to take your property from you. Taking your home from you, or taking your property from you, degrades your living condition. Slate Communications Incorporated versus Davidson. The reference in Section 32 of the Charter to the Parliament and legislator make clear that the Charter operates as a limitation on the powers of those legislative bodies. Any statute, which is an enactment, enacted by either Parliament or legislator, which is inconsistent with the Charter, will be outside the power of the enacting body and will be invalid. So the courts have already told us, right, that the Charter operates as a limitation against the government and against their laws and against their power. And if they choose to make an enactment that goes against the Charter, that goes against our rights, then it is invalid. It is of no force or effect. Now, in case some are under the misconception that a statute or an enactment only means those laws that they are creating, like the Highway Safety Code or the Consumer Protection Act, we look into the Interpretation Act of Canada. It states that an enactment means an act or regulation. And we look at the definition of a regulation. It includes an order, a regulation, a rule of the court, an instrument issued, made, or established under the authority of an act. So a court judgment is an order. A court judgment has been created under the authority of the court acts. So therefore, in law is considered an enactment. Therefore, and thereby, if the judgment of the court is inconsistent with the charter and your natural rights that are contained in the charter, then that court judgment is invalid. Christie versus British Columbia. The rule of law, a fundamental principle of our Constitution, must mean at least two things. First, that the law is supreme over officials of the government, as well as private individuals. All right, so for those who are out there teaching, right, that as a private individual, well, you're not subjected to any laws. Oh, this is a criminal code of Canada, you're not subjected to it. Oh, it's a charter, it doesn't mean nothing to me. Well, the courts have already said that if you take that position as a private individual, well, the law is supreme over you. And furthermore, it says thereby preclusive of the influence of arbitrary power. So the charter, our natural rights, natural law, is supreme over officials of the government and officials of the judiciary. And if they make judgments that go against our natural rights, then they have no operation of law to do so. And they are using arbitrary power against you. R versus Wagner. The Chief Justice goes on to note that these rules bind the legislative and bind the executive and bind the judicial branches. Well, what rules are you talking about? What are you talking about? We just saw, right? The rules that said the charter operates as a limitation on the powers of those legislative bodies. That enactments or judgments inconsistent with the charter will be outside the power of the enacting body and will be invalid. That this law is supreme over officials of the government as well as private individuals. Those rules. That's what he's talking about. Finally, at the developing fringes of the new natural law, which goes by the name human rights. So what are we learning here? That natural law in 2024 now goes by the designation, now goes by the term human rights. So if you want to find your natural rights, and if you want to find your common law rights, you can't go looking under a rock, and you can't go looking here and there. We've already been told, and it's already been given to us, that they are contained within the human rights instruments that have been created internationally and domestically. Now, if you want to kick against that, and if you want to oppose that, then you're going to be walking like a man in the darkness with no light, no flashlight to see where they're going. Because they've told us already that our natural rights are contained, are put in, are expressed under human rights. It rests on the proposition that there is a distinction between rules and the law. Rules and rule systems can be good, but they can also be evil. When arbitrary power is used, when judgments are made that are removing and abridging your natural, fundamental human right, then those rules are evil. Judges, therefore, must stand against the winds and the rains to uphold them, to uphold human rights, to uphold natural law. It is the judge's obligation. It is the judge's duty. And you got to stand against the capitalistic spirit. And you got to stand against a democratic society. And you got to stand against statutory law. That's your obligation. That's your duty in the office that you sit at. Natural law, human rights, they trump statutory rights. They trump civil rights. Those unwritten principles tend to be largely replicated in the text of the Constitution, with Section 7 of Canada's Charters of Rights striking me as a prime example. Our written Constitution reflects many, many influences, including the drafters' awareness of natural law. So they're telling us that our natural rights, our human rights, are contained within the Charter. Our common law rights are contained within the Charter. Natural right, a right that is conceived as part of natural law and that is therefore thought to exist independently of rights created by the government or society. So a natural right exists independently of the government. It is not created by the government. It exists outside of the government realm. International Covenant on Economic, Social, and Cultural Rights, Article 11. The state parties to the present covenant recognize the right of everyone to an adequate standard of living for himself and his family, including adequate food, clothing, and housing, and to the continuous improvement of living conditions. They recognize the right. Well, what right are they recognizing? Well, they're recognizing the natural right that exists apart from government. And that natural right to have a home, and that natural right to be allowed to have improved living conditions, that right cannot be limited and abridged. It cannot be taken away from you. And if they use a statutory power, if they try to use a judgment to take away that right from you, then it is of no force or effect. And they are operating arbitrary power. And their actions are illegal. And the way they built up this system, and the way they created this system, they're banking on the fact that you are not going to know how to counteract their measures, and that you are going to yield yourself to their actions. I want you to listen up here. Really pay attention to what I'm about to say here. Fundamental law. What does that mean, fundamental law? It means primary. It means first and foremost. The organic law, the natural law that establishes the governing principles of a nation or state. Constitutional law, also termed organic law, ground law, or natural law. So fundamental law, primary law in Canada is not statutory law. It's not civil rights. It is natural law. It is human rights. Thompson Newspaper Limited versus Canada. While individuals, as a rule, have full legal capacity by operation of law alone. Well, what rule are they talking about? What law are they talking about? Well, they're talking about fundamental law. They're talking about natural law and natural rights, which are better known as human rights. Artificial persons are creatures of the state and enjoy civil rights and powers only upon the approval of statutory authorities. The individual may stand upon his human rights, his natural rights, and in doing so, he owes no duty to the state. How much clearer can that be? How much clearer can that be? If you stand under natural law, if you stand under your human rights, then you owe no duty to the state. You and I possess many natural rights, not just a few. And those natural rights are expressed and contained in international law and in domestic law. And we have to claim those rights back from Canada. We have to let them know our position. We have to let them know our standing before them. And that's what a claim of recognition does. A claim of recognition is you claiming back your rights. You claiming your right to stand under natural law, under your human rights, without being infringed upon, without being placed into the capacity of a statutory creature. And as you saw in my other video, unless you have a claim of recognition, unless you have a claim of right in play, then you don't have the measure available for you to stand against the tyranny when they come to try and take your home from you. Artificial persons are creatures of the state and enjoy civil rights. A juridical personality is an artificial person. An artificial person is created by law and given certain legal rights and duties. So an artificial person, it's created by law and it's given legal rights and duties. But a man or a woman, they have rights already with them. And these rights exist independently of those that are created by the government. Two different standings. Slate Communications versus Davidson. It follows that any body exercising statutory authority, for example, the governor and council, or lieutenant governor and council, ministers, officials, municipalities, school boards, university, administrative tribunals, and police officers, is also bound by the charter. And remember, a police officer takes an oath to the charter. Action taken under statutory authority is valid only if it is within the scope of that authority, since neither Parliament nor a legislator can itself pass a law in breach of the charter. Neither body can authorize action which would be in breach of the charter. All right, so let me ask you something. When they come with their court judgment from their statutory court, when they come with the bailiff and they knock on your door and they want you to leave and they want to change your locks, are they in breach of the charter? The limitations on statutory authority which are imposed by the charter. So the limitations on statutory authority which are imposed upon them by our human rights will flow down the chain of statutory authority and apply to regulations, bylaws, orders, decisions. Well, I got an order from the judge. I got a decision from the judge. And all other actions, whether legislative, administrative, or judicial, which depends for its validity on statutory authority. So it's very clear, right? There are limitations upon statutory authority. And these limitations are imposed upon the statutory authority by the charter, by our human rights. So when they knock on your door with a statutory instrument and they want you to leave your home and they want you to kick you out on the street, is there not a limitation against them? Can you not enumerate and bring out the limitation that is against them? For they are standing against you with a statutory authority, and that statutory authority is trying to limit and abridge and steal your natural right, your human right. The bailiff comes with the court order. The bailiff comes to your property under statutory authority. And the bailiff is carrying a court order under statutory authority. And both of those statutory authorities are subject to our human rights. They are subject to the limitations imposed upon them by the charter. Well, excuse me, sir. It's the law. It's the law. I got a court judgment. It's the law. Yes, it's the law. Canada Attorney General versus Sam Levy and Associate. Any law that is inconsistent with the provisions of the Constitution is, to the extent of its inconsistency, of no force or effect. So you got a judgment to take my home, right? But guess what? It's of no force or effect. Why? because it's inconsistent with my natural rights. It's inconsistent with human rights. I have the right to a home. I have the right to adequate housing. And if you try to take my property, you are breaching my right. You are stealing my right. The invalidity of the legislative provision, of the law, of the judgment, inconsistent with the charter, does not arise from the fact of its being declared unconstitutional by a court, but from operation of Section 52 of the charter alone. So we are being told it doesn't take a court order to stand for your human right, to stand against a statutory authority that is coming to limit and abridge your human right. Thus, in principle, such a provision is invalid from the moment it is enacted. All right, you hearing that? You hearing that, Judge? From the moment it is enacted, it is invalid. Your statutory instrument is garbage. Your statutory declaration is garbage because you breached natural law and you breached Canada's obligation and you breached the charter in your enacted judgment. And the law says a judicial declaration to their effect is but one remedy, just one, among others, to protect those whom it adversely affects. All right, so getting a judgment against your house, getting a judgment against your home because you couldn't pay the mortgage, or because CRA laid a judgment against your home, that's going to adversely affect you. That's going to limit and abridge your natural right. And there are other measures in operation to protect you from this tyranny. And the other measures that exist to protect you and protect your human right to have a home, to have a place to live in, is found in the Criminal Code of Canada. As described in my last video, you need to have a claim of recognition in operation. In the claim of recognition, you are claiming your rights. You are making a claim of right to your natural rights, to your human rights. And therefore, when they come with a statutory power that is inconsistent and that is against your natural rights, the Criminal Code of Canada will protect you. There's the other measure they provided for you. But with that measure, right, it's going to take some guts and some courage. And they're banking on the fact that you're going to yield to them and you're going to give in to them. Well, I hope you don't anymore. And I hope you realize that their actions are illegal. Their actions are against foundational law.